90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is Attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we're going to discuss consumer debt and defenses to that debt. Our special guest is Jessica Brewer. She's an attorney who supervises the Lawyer of the Day program in the Manhattan Civil Court, where her staff of attorneys, her volunteer staff of attorneys, assist people being sued over consumer debt in fighting those cases. And the information she gives can be valuable to consumers anywhere in fighting debt and just being careful about negotiating settlements and signing away their rights. Jessica, welcome to Law You Should Know.
Thank you for having me.
So explain to us about the Volunteer Lawyer of the Day program operated by the New York County Lawyers Association.
Sure. So we operate at 111 Center Street. It is a volunteer program with certain attorneys that we have. The program itself is in operation Monday through Thursday. There's a 9:30 a.m. calendar and an 11 a.m. calendar. We are there for both of them, and we help exclusively with consumer debt matters. Usually that entails credit card debts, some medical debts, car loans, and things along those lines. Very few student loans, but sometimes.
And I do want to mention that lawyers or law students outside Manhattan can volunteer for the program, perhaps when they're traveling into Manhattan for something else, and learn about this field and do so pro bono work as well.
Yes, we encourage it. The more volunteers, the better.
Although each case may be small, consumer debt adds up to billions of dollars a year and is very important who these claims are against.
Absolutely. So we see cases that are $50,000 and below. However, we're seeing anywhere between 20 and 50 a day. So that really adds up, and that's just in Manhattan.
And you're helping the public to defend these cases, especially at the first time they're on in court, to prevent default judgments, to prevent erroneous charges or excessive charges that will be harder for them to overcome in the future if they consent to that debt.
Exactly. So we're a limited scope program, so we help as many people as we can in a day, meaning that we help for that day. We're not helping outside of court, but we can help as many times as the client is there and we are there. So we'll give advice and exactly explain every option that the client has.
So you're not representing them per se, but you're looking at the documents, you're giving them advice, explaining to them what some of their options might be and what a defense or negotiation strategy might be.
Exactly. And we'll help with the negotiations, and we'll also help with speaking to the judge and making sure that what needs to happen does happen and facilitating that.
And will you also be able to look at the agreement before they sign it to make sure it reasonably covers what the client agreed to?
Yes, exactly. We will go over it in detail with the client, and then we will also go before the judge most times with the client as well. In the consumer debt part, what all the judges do is called allocution, which means that the judge is going to ask the client or each pro se defendant questions about that stipulation as well to ensure that the plaintiff gave a proper deal and that there's a little bit of equity there.
And they're doing it of their own volition.
Exactly.
And you also want to make sure the client understands what they are agreeing to so that hopefully they can comply with it and that will resolve the matter.
Absolutely. Because if they don't understand what they're signing, that can lead to much more trouble in the future because they're waiving quite a few of the defenses that they may have should they have not settled the case.
And you're not keeping them from asserting those defenses if they choose to do so?
Absolutely not. We let them know what the options are for the case that day, as well as moving forward, certain things that they may be able to say. Of course, if they don't have discovery yet and we haven't been able to go through it, we can give advice as to what we expect the discovery to say, but we always let them know, we won't know the full set of your defenses until we see that. If they choose to settle anyway, not a problem. However, just letting them know everything that they have in their toolbox.
And you're also giving them some general information that they can use to negotiate with the creditor. There might be a statute of limitations defense. Maybe they never received the goods or services. So you're helping them to assert, general defenses that may be applicable to them.
Absolutely. And we see the same creditors day in, day out. So the volunteers, we all know what the parameters of settlement start at. We know if, it's a third party debt buyer coming in and they're offering a huge amount of that debt as the settlement, that's just really unacceptable. So just letting them know that as well. Because
the creditor may have purchased the debt for 5% of the debt and is just trying to get a windfall out of it.
Correct. Exactly. And the debt could have been sold multiple times. And, at this point, it's pennies on the dollar to the actual debt amount that they're attempting to collect.
And again, just to reiterate, the statute of limitations may have run. Perhaps the consumer did not get the goods or services they were promised, and maybe they even have counterclaims.
Exactly.
So you just want to level the playing field.
That's the whole goal, is to make sure that pro se defendants know what their rights are and aren't walking in being against an attorney, not knowing what's going on and losing out on defenses that they may have.
And once there's a judgment or some type of agreement, it's going to be harder for them to fight. And maybe they're trying to build a good credit history or get to a better place economically. And this may act as a ball and chain and keep them from doing so.
Absolutely. And above and beyond that, there are times where there are pro se defendants who are what we call collection proof, meaning that if there were to be a judgment entered against that person, that the creditor would not be able to collect on that. So there are certain income streams that are not able to be collected with a judgment. And let's say somebody's just on Social Security disability, just on Social Security retirement, a pension, things along these lines, workers' comp, unemployment insurance, and are settling. That is not money that can be collected. So it's also important to discuss in the budget if this is really there.
And if they sign an agreement to pay a certain amount, might they then be obligated to pay that regardless of the source of the money that this would impact upon?
Yes and no. Yes, to the extent that they've waived other defenses that they may have within the lawsuit. No, to the extent that if they default on that new agreement, because it is a new agreement other than the agreement that they had made with a creditor, then there would be a judgment against them entered, and the same issue would arise there where it's collection proof.
But before there's a judgment entered, they may unwittingly take money that's protected and use it to pay the creditor.
Exactly. And while that's somebody's choice, which I won't take away from them, it is very important that they know that maybe that income stream is protected and maybe that isn't something that they need to be paying with.
And maybe that could be used in negotiation strategy as well.
It absolutely can. We call that a hardship declaration, which is kind of a term of art in the consumer debt realm. But sometimes there's information that we can give even to the plaintiff, and they may discontinue the action altogether or come down substantially on the debt once they know that the defendant is collection proof.
So to reiterate, you just want to help that person assert their defenses.
Exactly. And we want to make sure they know them before interacting with an attorney on the other side.
There's a debtor going to court, a civil court. Let's say it's in Manhattan or perhaps some other place. They should look for resources available to help them.
Absolutely. So in all 5 boroughs, there are similar programs. My particular program, as I mentioned, is in Monday through Thursdays in the mornings in court. There are similar programs in each of the 5 boroughs. They each have different times, but it's all called Volunteer Lawyer for the Day program, consumer debt. They should be able to ask in the court and find whoever is there to help, or ask for an adjournment to a day that somebody like me is there in court.
And even if someone's outside New York City and they're in the court of, let's say, the lower jurisdiction, which might handle these types of claims, they should also tell the judge they need time to contact a lawyer or to find a free lawyer or some kind of legal assistance program or something, legal aid for civil cases. They should assert that, or maybe they can just to bring a friend with them or someone else who can help give them advice and look over the papers they're about to sign.
Absolutely. They should always, and a judge should always give them time to do that, to make sure that they have really looked into everything that they can possibly look into and that what they're signing is in their best interest.
But it's important they show up, because if they don't show up, taking a default against them, the worst possible case against them, they can't ask for a delay, they can't ask for additional documentation, they can't assert their defenses or try to negotiate it.
Correct. I usually tell everyone that 90% of the actual case and all of it is appearing in court and making sure you are there, or making sure that if for some reason there's an emergency and you can't be there, that you have let that court know what is going on and why you're not going to be there, and then calling repeatedly to make sure that they did adjourn that matter. But that's 90, if not 95% of the entire matter is showing up.
And that it's showing up and then protecting yourself, asking for information you're entitled to, asking for an adjournment if you need it.
Exactly.
I just want to remind everyone we're talking with Jessica Brewer of the New York County Lawyers Association, Volunteer Lawyer of the Day program, and she directs and coordinates and monitors the program. You're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. If you missed any portion of the program or you want to tell someone else about it, just go to the podcast at nccradio.org. Keep in mind there may be similar programs or resources available through law school clinics, legal aid organizations, or local bar associations. So always look around the court and ask the clerks if there's any support. And if not, maybe adjourn your case and take the legal papers and whatever documentation you have over to a bar association or a clinic to get some kind of help. Jessica, tell us about the experience of the lawyers or the law students from Manhattan or just spending a day or part of a day in Manhattan. What does this mean for them?
So with law students, we have a student practice order, meaning that once they've taken the training and observed for a little bit, they're actually able to, under my supervision, interact with clients as well as go before the judge. So it's a really great learning experience, not only with direct client interaction, but that interaction with the court and really learning how to get your feet wet with that. So I think it's a wonderful opportunity for law students to come and volunteer with us. It also counts towards their 50 pro bono hours towards bar admission later on. When it's experienced attorneys, I love to have them. It's oftentimes people who have been in different fields learning about the consumer debt realm. And I think it's great. I think it's exciting. It's fun. It gives that direct client interaction that perhaps I'm wrong, but I think a lot of people love and like to really interact on a day-to-day basis with who is there and who is coming into the court.
And as you mentioned, it's litigation experience, both for attorneys and for the law students. It also could be a valuable networking experience. So they're meeting some of the law students and attorneys meeting some of the lawyers. They're making contacts. And that's what being a lawyer or a law student is about. And it's always good to do pro bono work as well.
Absolutely. And they're meeting judges who are on the bench and who may be on a different bench that they're before one day as well.
Right. So they're meeting judges, and the judge might recognize them and from that court appearance. And so they're a more of a known entity and will impress the clients, the paying clients they have in the future.
Yes, absolutely.
Now, you also help consumers manage other debt issues. What advice do you have for consumers anywhere before they take on debt or in fighting debt?
So before they take on debt, I think it's very important to read closely and review what the terms of the debt that you are taking on are. So for instance, we see a lot of credit cards that have maybe a year of no interest, and then the year after that, the interest is in the 20% high and higher. And that means that each time you're not making a full payment, you're getting interest on what you've already spent and what is on your balance. And sometimes that gets very hard to get out of, because when interest is very high, you're then often each month just paying off the interest instead of the principal, and it grows and grows until there's an issue. So I think it's incredibly important to make sure that whatever card you're opening, whatever you're doing, you're making sure that you know the exact terms and staying on top of that to ensure that if it is a year of no interest, you know what happens after that year.
And it is a slippery slope because if you miss a payment, there may be a lot of interest that accrues, and you really don't want to do things beyond your means.
Absolutely.
If you can avoid that. But they make it's almost like predatory lending. They make it too easy to get those credit cards and make it sound like there's unbelievable terms, but they can come back to haunt you.
100%. And it's better to be informed at the start to know what's going to happen once those perks of that card wear off.
And once, let's say they're fighting a debt, they're in court, wherever it may be, or you're helping clients in the New York civil courts, will the creditor take that into consideration, that you have no assets or you might go bankrupt or whatever it is, to take something on the dollar if you have the resources, maybe from yourself or maybe from a friend or relative, just to get rid of that debt?
Once you're in court, they may or may not, quite frankly. It depends on how large the debt is and how much you are able to pay on it, and then what your financial situation is. So if you've provided what we call a hardship affidavit, it is within the plaintiff's right to reject that and to say, no, we want to move forward. We want X amount, and we're not coming down from that. So while I find it helpful, it does not necessarily mean that they are going to come down to an affordable amount. We often do find that we can get them down to an affordable amount. It may take more than one court visit to do so. However, there is time that they're just not going to do it. I call it maybe they just want the judgment for wallpaper. They know they're not going to get anything from it, but that's a business decision that if I had insight into, I would love to share it, but it's not how I would do it.
Does it make a difference whether it's someone who bought the debt or whether it's the original creditor?
It absolutely makes a difference. So the original creditor has a much easier time proving their case. And since they are the plaintiff, it is their burden to prove their case and that you owe those funds and that they have the right to collect on those funds. When it comes to a third-party debt buyer, they need to prove not only that they purchased this debt, but that it was your debt. They have a right to collect on these funds. And we find quite often that they won't show up prepared to a trial date for that. So they may. I always say there's a chance that the third-party debt buyer attorney will show up with a witness, which is somebody from that third-party debt buyer, to speak to the documents. However, I find most of those documents wholly insufficient, and
there may be holes in them too.
Oh, many holes, yes.
And what if the goods, the refrigerator, the washing machine, the piece of furniture, were defective or did not last?
Sure. So that will depend on the underlying contract sometimes. That will also depend on when this all happened. So oftentimes with cases when it's a retail installment contract, I have found that if it's a furniture store or something like that, this may be something that happened quite a few years ago, and there's no documentation from the defendant saying what happened, saying that, this didn't arrive the way I wanted it to, and it makes it more difficult for the defendant to prove. However, it is a defense.
And if you made calls or you wrote a complaint letter, it's good to bring proof of that?
Yes, I think that's the other side of your question earlier about how to protect yourself. Always keep records, even if it's a picture on your phone. Just keep as many records as you can of things of this nature so that you can bring that if there's an issue in the future.
And a picture might be worth 1,000 words and bolster your claim.
Absolutely.
And if you had problems after something was installed, after it was received, try to, have a log of those complaints.
Absolutely. If you send a letter, keep a copy. with when you sent it, things of that nature, a picture of it, send it in a follow-up email too, things like that.
Can you sometimes, is there more room to negotiate the outrageous interest charges and just pay off the debt itself, or creditors are not usually that flexible?
It depends on the creditor, quite frankly. We see a couple of the original creditors who just really do not want to budge.
Right.
It also depends on the amount of the monthly payment that is being offered. So we'll see that a lot of the original creditors deal in months. So how many months can it be paid off in? So they'll come down a lot lower if the monthly payment is higher. Third-party debt buyers, if you're paying more than 50%, don't agree. And even that's high.
And also, if you receive a bill and you think you have a defense, or even if you think it's unfair or not what you agreed to, you should dispute it and say
Absolutely.
Proof of that dispute. Because if they don't respond to that dispute, that might affect their rights down the road, including interest.
Absolutely. And then you have a great reason to say, well, I've been disputing the amount of this debt, even before you sued me. Here's how I've been disputing it.
And do you have to dispute it each time, or one dispute is enough?
I think the more that you do, the better, quite frankly. I think especially in a court like this, where it's very high volume, the more you have to bring and show, the better.
So you want a mountain of evidence if possible, or a mountain of complaints?
If possible, yes.
I just want to remind our listeners, we're talking with Jessica Brewer, and she's in charge of the Consumer Protection and Debt Program of the New York County Lawyers Association, and she oversees volunteer attorneys and law students in the civil court in Manhattan, which hears these cases, and there are other civil courts in the other boroughs. There are cases in the lower courts around New York State and around the country, and she trains lawyers and law students to assist the debtors in disputing these cases and to keep them from becoming a judgment, which becomes a ball in a chain and makes it harder for the defendants to get credit in the future. And maybe they have very good defenses. If you missed any portion of the program, just go to our website at nccradio.org. And you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. Jessica, what other thoughts do you have for listeners to dispute consumer debt?
I think it's always important, whatever you get from a creditor, make sure that you are checking it. We talked about the statute of limitations now. The statute of limitations after April 7th, 2022 is now 3 years. So we're seeing people come in with other letters from creditors that the time has passed to sue and really collect on this.
But if you don't assert that it's past the deadline, also called the statute of limitations, you might lose that right. This is like a really bar. They can't really come after you, but you have to tell the court that.
You do have to tell the court that. You can bring it up at trial. It's better to bring it up early and throughout the case.
Now, how could a consumer unwittingly extend that deadline? Like if they make a payment or sign a new agreement, what are some caveats for them?
Exactly. So if somebody is some creditor is sending you a letter, you must pay, don't worry, and you call, oh, don't worry, just send us $10, just send us $20. That could then extend the time, because usually when the statute of limitations starts to run is your last date of payment. So what they're calling the date of default. So
you might keep the old debt alive unwittingly by making a payment, even though it's so old.
Exactly. And there are ways to fight that, but it gets a lot harder once you start making payments.
And what about people calling you, debt collectors calling you? Is there any way to stop that?
You can tell them to. If you look into the FDCPA as well, there are certain things that they are not allowed to do, certain times that they are not allowed to call you, certain amounts that they are not allowed to call you, and you do have the right to give them a stop calling me notice.
And it's also good to ask for verification in writing of any documents about it, so you can check the dates, and yes. You can even ask for a payment history.
Yes, and I also think it's always important with any credit card, any debt, things like this, to not just accept a phone call from somebody who's calling you. say that you are being sued by an original creditor, you have a credit card with them. If you get a call, hi, this is, X creditor, always make sure that you're then looking up the number that is online for that creditor and you are calling to make sure.
Can you just tell them, confirm everything in writing? Because you could be exposing yourself to other risk if you give them a credit card on the phone.
That's exactly true. So you can always confirm in writing. Just make sure that who is calling or writing to you is actually who they say they are.
But at least get something in writing, and then you can explore whether they're really there. You can look them up. You can Google them, see if it's the real agency.
Absolutely. And never give out information if somebody's just calling you.
Never give out your Social Security number. Don't give out your date of birth. Maybe verify your mailing address, but don't give them your date of birth. Don't give them your credit card number. Don't give them Social Security numbers because they can be abused, even if they're a legitimate creditor. How can attorneys or law students who want to volunteer with your program get in touch with you?
They can email me at jbrewer, BREUER, at NYCLA.org, or they can call us at 212-267-6646. And we will direct you to probably me or different ways to do it.
And you'll give them some kind of training or support.
Absolutely. So we have in-person trainings once or twice a year, and then we also have pre-recorded trainings, and I'm always there for support as well.
And very briefly, what kind of commitment do you need from the lawyer or the law student who wants to volunteer?
So it really depends. We coordinate with the courts as well with our volunteers. There is CLE credit that they can get. So if they want the CLE credit, I believe that they owe about 12 to 16 hours. However, if they don't and they just want to observe, feel free to email me and just come down.
And it's a good experience all around. Okay.
I certainly think so.
Okay. I'd just like to thank Jessica Brewer for talking to us about consumer protection and debt. You're listening to 90.3 WHPC, the voice of Nass Community College. If you missed any part of the show, just go to nccradio.org, and please join us next week at this same time for another program on Law You Should Know.
This year, over 50,000 law enforcement officers have been assaulted while on duty. A vast number of these attacks were filmed and uploaded to social media in the pursuit of likes and attention.
What they want to do is film you instead of what can I do to help this officer?
Together, we can change this disturbing trend.
If that individual would have hit the right spot, it could have been it for me. Last time I would have saw my wife, my kids.
I'm Mike Solon. Law enforcement officers need your support. If you see an officer under attack, then follow these simple steps in order to help. 1. Call 911 and give the officer's exact location. 2. Ask the officer if you can assist. If the officer accepts, then do whatever you can do to safely help. 3. If the officer declines, then start filming and be a good witness. It's time to stop filming and start helping.